On this side.
Yeah. So who's speaking?
Yes.
First thing first, you understand that you are no longer an
No.
So
We remain as consultants to him and as his brothers and braves in council.
okay, based on today's proceedings, what did you observe and what to do with it?
Well, my observation is that let's keep in mind that 14th October this year made it 10 years that this case has been pending. That the matter has become too complicated for the judiciary to handle underscores our core point that this matter is more political than legal. That this is a matter for the executive branch to settle with a political sleight of hand. It's not a matter to be offered to the limited wiggle room of a court of law, of the judiciary. There is a lot of wide berth, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Mazi Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the power. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empowered the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the
Procedure today?
The proceedings today.
Okay.
What next?
I will yield to one of my colleagues to discuss that. By Sama Square, Opera will proceed.
Okay, actually, it's good for us to put the record straight. Mazi Nnamdi Kanu is not saying that he will not enter defense. Mazi Nnamdi Kanu said, under what law are you charging him? Going by the Constitution, there is absolutely no charge against him. That tell me the law, that the court should tell me the law upon which he's being tried. Now, my lord is on so saying that whatever thing that you have to say should be included at the final written address, and it should be upon a conviction to know whether they're supposed to be convicted. I'm not saying that said no. There are thresholds, there are hurdles upon which you need to cross, you need to reach that particular issue. And one fundamental issue there is that my law said we are talking about issue of extraordinary rendition, the way we are being brought back from Kenya to Nigeria. And he wants somebody to come and give evidence on that. There is nothing before him. And if you watch the motion of Mazi Nnamdi Kanu file, Mazi Nnamdi Kanu said Federal High Court has given a judgment in respect of that, and also awarded 500 million against federal government in his favor. That judgment is in the court file. Court of Appeal, in their judgment, also gave ruling on that and made comment about that. CTC of that judgment is in the court file. Supreme Court, in their judgment, also took judicial notice of that and they condemned that attitude. They are all in court file. There was a motion challenging the decision of the court where these issues are being raised, and Mazi Nnamdi Kanu made reference of the motion in the court file. And under the Evidence Act, Mazi Nnamdi Kanu is saying that under the law, court is is obliged, is under obligation to take judicial notice of every document in your file.
Yes.
So asking him now to go and enter into a defense and start giving evidence on that is a waste of time.
Yes.
That court is on its own supposed to take so much to raise this issue.
Yeah.
Court is expected to raise this issue. Now there is a charge before me. Please, under what law? Address me on this issue before I go into trial. And Mazi Nnamdi Kanu filed a motion, and I think that motion, Mazi Nnamdi Kanu said that motion should be heard, and all this issue I raised should be tracked for me to go into trial. So I'm into defense. So my law, Mazi Nnamdi Kanu maintain his position on that. So my law said that he has gone to tomorrow for him to get that defense. Just like we said, you know, we are no longer into the matter, but we are still consulting us. I am saying so on handling his matter in court. He felt that he's competent to do that. So whatever advice he needs from us as his lawyer, we should also offer the legal advice just to get the record straight, so that people will not say that Mazi Nnamdi Kanu refuses to enter defense. No, there is no such issue. Mazi Nnamdi Kanu said, address me on this issue. Okay, that's
the honorable member here would like to say.
Well, my name is Right Honorable Obi Akocha. I represent the great people of Iguano, Umuahia North and Umuahia South for the constituency of Abia State. I represent Mazi Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended, for the Attorney General to enter a nolle prosequi, at least before the determination